What are your thoughts regarding finding... Thank you for staying with us. It's time for Checkpoint now on Twitter. The hashtag we're using is Checkpoint. SMS number is 22155. As we discuss the week that was in terms of the ICC, politics, and most importantly, like we said, justice for the victims. My panel tonight, Patrick Gadara, who's a blogger. We have Esther Waweru, who's a human rights activist. She's actually with the Kenya Human Rights Commission. And Ngunjiri Wambugu, who likes to call himself a political commentator. We'll take that for now. Let's start with you, Ngunjiri. Yes. You described it before the break as brilliant theatrics that we saw last week.
Theater.
Brilliant theater.
Yes.
Okay. Why'd you describe it that way?
Politics is about perception. And perception is about communication. And what we actually saw last week is brilliant political communication by Jubilee. All the way from the beginning, actually, just from the beginning, towards the end of last week, when the whole country was stuck.
With bated breath.
Yes, literally.
Yes.
And they built this up. It was a deliberate investment in getting Kenyans to the point where they were all not sure whether he was going or not. By Monday morning, actually all throughout his speech, I think he must have been watched by more Kenyans during the time he was reading that speech.
And for you, it was brilliant, and it sent the right perception, because you said it was. I'm a
political communications expert.
Was it the right message?
He sent the right message. For one, what he actually did was very simple. He said, "I'm going as an individual. I'm not going to drag Kenya to the court.
Okay.
I say this is personal, and I'm doing it." But then the way he did it is now what the theater is.
Gadara, do you agree? Yet he did come back triumphant. Sort of like Jesus coming back into, if you recall, on a donkey. I don't know. That analogy just seems interesting.
Yes, he come back, quote unquote, triumphant. But let me disagree a little bit with what Ngunjiri says. It was theater, but I think it was more theatrics. It was unnecessary. And I think, actually, from a political point of view, we should have never been in doubt whether or not he's going. And the fact that he did create that doubt was bad. You know, our constitution is clear that he was obligated essentially to comply with the order of the court. The second thing was there was quite a lot of sort of unnecessary handing over. This is not the first time the president has left the country. You know, and we all know every time he goes, and they've told us this before, that the deputy acts. We never have this big
so for
show
you, this was unnecessary.
Over. It was totally unnecessary. You know, it was good. I'm not saying that he doesn't have the right to do it. The Constitution does give him the right to do it, but I think the Constitution more anticipates a situation where he's still in the country and hands over. You know, because when he leaves, when he is absent, it is clear, and Section 147, which he quoted, is self-effecting. William Ruto becomes or acts as president, immediately goes. And one final point, Ngunjiri says that he goes there as a personal citizen.
As an individual.
Was always charged in his personal capacity.
It wasn't any different this time around.
But the more important point here is that even after he left, he did not cease becoming president. So, in a very real sense, still the president of Kenya was in front of the ICC. You know, all these hullabaloo that they created cannot mask that fact.
I'd like to make a correction. I'd like to make a correction. I've had a lot of people say that, and in fact, including very experienced politicians, saying that every time that the president leaves, Ruto is acting. That's not the case. When the president leaves, he leaves. He's a president wherever he's gone. If he's gone to the summit, if he's gone to Uganda for a presidential function, he has gone there as president. He doesn't leave anybody acting because he is the president. He's acting as the president wherever he is. What happens with this particular case and what they did is, like, for example, it happened once with Reagan. You're going in for surgery, you might be out for a couple of hours. In case a decision needs to be made, an executive decision, that's what you've passed over. That's what he did. He said, I'm going to be in The Hague for 6 hours. In case something happens, you can make a decision.
In case what happens?
Anything. We could go to war.
Like
Somali could invade us.
Or like he could be held at The Hague?
Well, even that.
All right. Esther, let's bring you in, because with all of this is I think what gripped the country's conversation for the entire week. Did we forget what this was all about?
Yvonne, I think sadly, for some couple of hours, we actually did forget what this was all about, and we made it about the accused person, the president.
And what
we
is it about,
forget
sister?
that there are actual victims who suffered real harm, and those victims have never had justice to date, and they still look to the ICC to deliver the justice that they've been looking for over 6 years now. So the fact that, you know, the president appearing in court becomes now the talk, and we forget about why, and the president has been accused and actually charged with crimes against humanity, is totally to miss the point, in my opinion. But we made it about, you know, the accused person and forgot about the various victims who still continue to suffer. You have victims who were raped, infected with HIV. No one talks about those victims in as much as, in the same breath that you have us talking about the accused person. You have persons who are still living in camps that are long forgotten, and no one is talking about them. On Sunday, KTN aired an article about refugees in Uganda, more than 1,500 victims.
Right.
Who's talking about them? Did we ever stop to think about them? I don't think so.
Ngunjiri, are we still thinking about them?
You see, this is the problem we have. The system we have, the ICC system, doesn't focus on victims. It is a retributive system. It's a retributive
But there's
justice
also
system.
reparation.
It is we've never seen it happen. ICC for its entire duration has never reported anybody. It's never
So because
compensated
we've never
anybody.
seen it happen, does that mean it won't
you
happen
see,
in this case?
This is the problem we have. ICC is about punishment. And when you talk about punishment, you focus on the offender. Is he guilty or not? There's another system called restorative justice, which actually focuses on victims. That's not what we are in right now. The second point that because this question of victims and accused keeps coming up as if they are connected at the hip. They're not connected at the hip. We have victims. We don't dispute that. But then you don't frame someone. And I'm not saying that's what happened, but you cannot frame someone. If I steal Kadhara's glass of water, then you arrest her, and then you take her to jail and you fix her. We can't keep insisting she must go to jail because...
Ngunjiri, are you then saying that the president is being framed and is being fixed?
Look at what we've done. Look at what we have seen in the last 1 year. We have a system. For example, Bensouda went to court last year in March. She said she withdrew Mudaura's case. For the same reasons, she's insisting that Uhuru's case should be adjourned.
So is Uhuru being fixed?
As far as I'm concerned, that's where we are right now.
He's being fixed?
Yes.
Gadara?
No, I don't think so. I mean, Bensouda has gone, and even during the Riza Status Conference, was quite clear that it's not that she doesn't have any evidence, you know, and that's kind of the narrative that government has been trying to drive. She says at the moment what she has is insufficient to secure a conviction, but it's not that it's not there. You know, and she says that she requires the cooperation of the government to get things like the president's phone records, land records, etc., that she can tie in the gaps and get her evidence. You know, now as per the Rome Statute, our government is obligated to cooperate with the ICC. You know, with the ICC prosecution.
So, in your opinion, it's not that she doesn't have
and here's the other thing: is there's this idea again that's being pushed by government and its supporters that the ICC came up with Uhuru Kenyatta's name out of thin air. You know, this is again not true. You know, you go back, look at the working report. It named him. It named his deputy. You know, don't forget, precisely. And again, the cases before the ICC were confirmed, i.e., there was a reasonable, at least at the time they were confirmed, there was a reason to believe that Uhuru Kenyatta may have committed the crimes.
Hold that thought, Gadara. From a legal standpoint, Esther, shouldn't it be the court to decide whether he's guilty or not, or was being framed or not?
Before I answer that, can I just respond to something that Ngunjiri said? Right. I think it's fallacious for us to think that the ICC has nothing to do with victims. At the center of the Rome Statute system are victims. We cannot speak of accused persons or even suspects. If there are no victims, there have got to be victims. And the ICC is very ingenious in that it actually allows victims to participate in the proceedings against accused persons. It's also not true that the ICC has not had any form of reparations. In Uganda, we do have the Trust Fund for Victims that is already offering some form of reparations for victims in northern Uganda. So it's totally wrong to say that the ICC cannot and has never, offered reparations. But then now to answer your question, I think we ought to leave the court to do what it must do. And the court must, on an assessment of the evidence presented before it, then make a determination as to whether Uhuru Kenyatta is guilty or not guilty. It cannot be for us, just based on, mere politicking, if I may call it that, and roadside declarations, if as you may call them, to then say that he's innocent. None of us can actually call that judgment. It's up to the court.
Okay. This is not mere politicking. On March 11th, 2013, when the ICC prosecutor went to court and withdrew charges against Muthaura, the reasons she withdrew those charges were: one, the government wasn't cooperating. Kenyan government wasn't cooperating. Two, they had insufficient evidence. And three, they did not expect to get any more evidence beyond what they had. She then said that it is her responsibility to pursue only those cases where she's sure she's going to establish a conviction. That was the reasons she used in Muthaura's case. And she withdrew the case. And she actually told the court that they really don't have to give her permission because it is her right to withdraw the case. Now, that same situation exists in Uhuru Kenyatta's case. Remember, the ICC court and the ICC prosecutor have insisted that Uhuru is in court as an individual, not as a president. Now, if they have a problem with the government, they need to fight with the government. But
Which
they can't.
Did when the Attorney General was
but you see,
there,
then they're saying because we have a
day.
problem with the government, we need you to keep Uhuru as an accused until the government sorts itself out. Now, the problem becomes: what if he wasn't the head of state?
What
if he wasn't president? He got elected.
I think that kind of misstates it.
Yes,
I mean, the problem they have with the government is that it's not furnishing them with the evidence against this particular person. So you can't really
But he did the same
distinguish
thing with
and say
Muthaura's case.
whether or not he was president, whether he was somebody else.
Right.
I mean, the prosecutor will still be within her rights to insist that the government
Esther?
cooperates.
I think, again, let me remind Ngunjiri that the reason why the prosecutor withdrew charges against Francis Muthaura was not because the government was not cooperating, but it was because
in the submissions she made.
It was because that the primary witness upon whom the case was anchored, I think it was witness number 4, had withdrawn. It wasn't about cooperation.
Now,
cooperation has only arisen in the president's case.
Thank you, Esther. In the president's case, the two witnesses who the prosecution depended on to confirm the cases have both, one has been proven to be a liar, the other one has been proven to be unreliable. So at what point do some rules apply for Muthaura and don't apply
the fact that Besuda the other day, during the status conference, said she's got 9 witnesses that tie Uhuru Kenyatta to the financing of Mungiki to carry out
but
this.
Then what Kay has said is, if she has 9 witnesses, why aren't we having a trial? Why is she asking for an adjournment?
And this is what she said, and this is the important thing. She said it's not that she doesn't have any evidence. What she feels is
evidence.
What she has is insufficient to convince the court. So that's why she's going back and insisting that the evidence probably does exist. We can get it if the government would cooperate. The government is obligated to cooperate. It's not doing this.
Let's move this conversation in a bit of a different direction, because in terms of all of this that we're talking about now, it's about the legitimacy of the ICC that is at stake. And many people saying that the Kenyan cases have now sort of damaged the reputation or the legitimacy of the ICC court as a whole. And of course, you hear all these theories that now they will not get funding if there's no conviction in these cases. Some of those theories that are coming up. Earlier this week, I had an opportunity, earlier last week, I should say, to speak to Maria Kamara, who's the ICC field outreach officer in Kenya, on just that question. And that is exactly what I asked her. Have the Kenyan cases damaged the reputation of the ICC? I'd like us to listen to that, and then we'll weigh in. Let's listen in.
I didn't see anything like damage or dent. I just saw it increases the visibility of the court. There have been a lot of people that didn't know much about the court. Believe you me, you do a survey today about the ICC. Forget the negatives. Me as public information now, I'll say, go anywhere. People just understand what this court. Forget the politics, forget every other thing. But they know such a court exists, number one. They know where it exists. There is a lot of details that the people know. That right there at the grassroots level, they ask matured questions, process-based questions. And those are not ordinary questions if you're just passing by. you may have followed the process through and through to be able to ask those questions. So from a point of view of public information, it has increased the visibility of the court, so that a lot of people now know what this court is about.
All right, increase the visibility of the court. Ngunjiri, you have a smile on your face.
I feel really upset that we have a case of this magnitude. And all the ICC sees is that it's a process of increasing their visibility as a court in the international community. And unfortunately, I get the feeling that a lot of how this case has been processed, right from at some point when Uhuru Sai looked like he was going to be president, has been actually to build up the visibility of the court. And unfortunately, even this recent attempts by the prosecutor to ask for an adjournment, what she's doing is just keeping this case, because it's given them limelight on the limelight. Once it's terminated, that visibility is finished.
Esther?
I don't totally agree with Ngunjiri, but I need to say that it is true that more people are getting to talk about the ICC. We haven't seen this much discussion around the ICC, I think, since January 2012, when the charges were confirmed against 4 individuals then. But it's also important for us to remember that, of course, people might say that the court is, has been dealt a huge blow by the
so
Kenyan, a huge blow. I wouldn't call it a death blow by the Kenyan cases. But we need to remember that the ICC is quite a fairly new, young institution, and
It's been around for 12 years, though.
It has, but since when has it had cases? I think it would be wrong for us to assume that it was, a very strong institution that couldn't be shaken. But I also hasten to add that there are lessons that have been learned. And these lessons, I would hope that, of course, the ICC has also learned, and the Assembly of State Parties in order to strengthen the court.
Great. Gadara?
Well, my take is different. I think we've got to ask, number one, why we wanted an international criminal court in the first place, and actually why even Kenyans themselves wanted these cases. As you know, we had lots of opportunity to try these cases within, and we expanded. And I think the point here is, how do you hold, and this is a big question of the ICC going forward, however these cases are decided, we'll have to grapple with. I think the international community, and even us as Kenyans, should be concerned about is, how do we hold to account the people who hold power? This case, is not about the outcomes. And this is one thing I'd like people to understand. The ICC will not fall or stand by whether or not it convicts Uhuru Kenyatta. That is not the point.
Convictions will not...
The point is that, can somebody like Uhuru Kenyatta, president of a country, charged with heinous crimes, get onto the court, get a fair hearing, and either get acquitted or get convicted. All these other sideshows that we have, tend to obscure that central question. And how is the court based, and how enabled is it to actually deliver on that process that holds the most powerful people?
So convictions do not necessarily equal,
I mean, if for example, as the Bensouda has said, if she doesn't have evidence, and this goes to the judges will make a determination that there is no evidence and decide what to do about it. But that determination in itself is part of the process. And I think it vindicates the process. If he's actually let go or he's charged, both ways, it vindicates the process itself. And I think that's what we need to be concerned about. That can powerful people, by virtue of their position, subvert that process?
So lay themselves bare before the process of the court,
the government
regardless of the outcome.
For a very long time, they were saying that these cases should not be heard. That they should be deferred till these guys were out of power. Yet our own
Which is
constitution,
exactly what Bensouda is saying just now.
What our own constitution says, is that Section 143(4) is that the presidency is not a shield behind which people can hide.
All right, Gadara, I'd like us to move, because you mentioned something about justice for the victims, which is, I think, is what is top on our minds. Maheni Assam on Twitter says, victims' justice won't be found by ICC jailing the 3 suspects. Local justice mechanisms are needed. And so on that, have we equated conviction of the 3 people before the ICC now to, justice for the victims? Is that a fair sort of balance is that a fair equation?
I don't think it's a fair equation, because we must remember why the Kenyans are before the ICC. It's because we failed as a country to actually set in place local processes that would deliver justice. The Rome Statute specifically says that the primary responsibility to bring to justice the perpetrators lies with the state party. So therefore, ICC will only come in when a state party is unwilling or unable. And in Kenyan, in the Kenyan situation, it was totally a lack of political will to actually put in place a local tribunal as recommended by the Waki Commission, and various, at least 2 bills that were brought to Parliament for discussion were never passed. And that brought the clarion call of, don't be vague, let's go to the Hague.
All right, let's talk very quickly about the International Crimes Division that, we hear there's a task force that's looking into it. Earlier this year, when we heard from the DPP, and they reviewed close to 5,000 cases, and out of those, the DPP himself says they were not prosecutable. Are we doing enough in Kenya for us to even then say, look, ICC, leave us alone, we will not find justice with you, because we already have mechanisms locally?
I think if you will remember the Agenda 4 items within the whole National Accord process, National Reconciliation Accord process, there were certain steps that Kenya needed to take. Amongst them were institutional reforms. And unfortunately, we've only looked at institutional reforms as only being about judicial reform. And we've forgotten that in order to deliver justice, you need to look at the whole justice chain. So start looking at investigations, prosecutions, and the court itself, and the punishments after that. You need to look at witness protection. It's a whole myriad of issues. We can't just look at judicial reforms and say, well, we've done something. The whole idea around establishing an international crimes division is welcome to the extent that it will sufficiently and adequately deliver justice, specifically for post-election violence victims. You now have what is proposed by the committee of the JSC to set up an international crimes division that would not only look at international crimes as defined in the Rome Statute and our International Crimes Act of 2008, but will also look at other transnational crimes such as money laundering, trafficking in persons, poaching. And guess what, Yvonne? They want to use the International Crimes Act to prosecute those crimes. Just, from the outset, you're setting up a division that's doomed to fail, because it does not have jurisdiction if it will be established under the International Crimes Act to deal with those other crimes, other than the 3, that is war crimes, crimes against humanity, and genocide.
Okay, all right, and we'll come to you now as we seek the ways in which to get justice for them. Ngunjiri, as we discuss all of this, I think, the bottom line is justice for the victims.
Yes.
What for you would be that ideal route towards getting justice for the victims? And do you believe the ICC is the way to do that?
First and foremost, the question you asked earlier about whether we have equated convictions of these accused to justice for the victims, it's yes. I mean, the NGO, the international community, the ICC has sold us. The victim's lawyer has sold us the fact that if you let Uhuru Kenyatta, William Ruto, and Joshua Sang go, then victims will never get justice. They have presumed to tell us that these are the people who are responsible for the crimes that happened in Kenya. And this is their argument, and
not
we expect them.
Not responsible, though, Ngunjiri, the ones that they have evidence.
Yes,
that.
but you see,
and
to
the
them,
judges will decide.
Highest response. You see, the prosecutor is saying these are the people I believe
the prosecutor
are responsible.
would say that.
And
that's the role of the prosecutor.
Yes.
The
but then
judges
also
will decide.
we have a local conversation that's going on here, where every time you say there's a problem with this ICC process, you're told, but what's going to happen to the victims? So we've actually equated the issue of convicting.
All right. So what's going to happen to the victims for you?
First and foremost, I think a lot has already happened to the victims. You see, we some of us are stuck at 2007. A lot, this is 6-7 years ago, and a lot has already happened to the victims. First, we have
namely
the government conversation about compensation, but then that's, I have to admit personally, I do not think it's been complete. We've got a lot of integrated IDPs that have never been sorted out.
Right.
But then also, we have had situations where we've got communities doing local activities to reconcile themselves. Because remember, the post-election violence that happened in 2007 was something that had happened before. This is, the ICC is not going to jail 3 people and stop it. It's not going to happen. So Kenyans have to figure out a
way
local
of doing
process
that. Okay.
of reconciling
And
the communities.
there was
But
the
however,
TJRC
Yvonne, 1
report
minute.
which might have provided that, but
Yeah, but see, there's also one thing that we are forgetting. As we have this conversation about the victims, we also, I don't know how many people have actually gone back to the victims of 2007 and asked them what they think about the ICC process. Because the ICC came and sold us that they're not going to be manipulated. They're not going to favor
All right.
anyone.
So
but we have seen it happening.
Okay, so we're running out of time. So
Yes.
very quickly for you, justice for them would be what?
Would be a local compensatory mechanism.
Okay.
That's where
and
we
who's
have
the
to
person
start.
who would be responsible for that, though?
It has to be the Kenyan people. We keep
Led
saying
by?
sovereignty starts with us.
Right. And
Because-
who's
we
the
have-
person
we
who
have
would spearhead that?
We have gone and
Who would
elected
spearhead
people.
it,
We've
Mujeri?
elected our leaders, political
Okay,
leaders.
thank you. Our political
Yes.
leaders. All right, we'll leave it at that. Patrick, your final thoughts on this one as we go. We're running out of time.
Okay, on the issue of justice for victims, I think the primary responsibility for delivering that should rest with us. I think the ICC as a process is part of our law, so we shouldn't be thinking of it as an external court at all. It's part of our law, and I think the biggest problem people have, and I think even the victims' lawyer said it, is mostly because the process itself is not being allowed to work out. It's being politicized, and the government is trying to shut it down before it can go its
Very
course.
quickly, Patrick, do you think we've done enough locally for the victims?
No, we haven't. I think in a very real sense, when the DPP says there are 5,000 cases we can't prosecute, fact is we've got thousands of witnesses, thousands of victims still alive, still here. These cases can be reinvestigated, they can be, and perpetrators can be brought to justice.
Right.
This can happen, but we need to push for it. And in a very real sense, I think, to an extent, we've allowed the ICC process to mask the fact that nothing is being done.
Okay.
I'll give you one final example.
Right.
A lot of people are talking about the resettlement of IDPs. Two things. First, the conflation of victim with IDP is a problem because victims were not just IDPs, victims were people who were shot, who were killed and stuff.
Yes. Okay.
And
I
the
really
second
have to
thing
leave it
is,
at that. Very quickly.
just very quickly, last year in September, the government promised on the issue of IDPs that they would all get cash transfers, by the end of September last year, and in March, the president went in front of Parliament and said out of 8,298 households, only 777 had actually received this. This is less than 10%.
All right, Patrick. Okay, fine. Esther, just as we finish, is cash transfers even enough, or do we need a more cathartic process like what we saw with the Gashasha courts in Rwanda, just as we wind up?
I don't think cash transfers are enough. In order to get justice, we need to have the following things in place. One, we need to have an acknowledgement of the harm suffered by these victims. We need to have an apology for that. We also need to have retributive justice in the way of prosecution of those responsible for the violence. We also need to have reparations that are not only in form of cash, but those that actually respond to the needs of victims. So you need to have a proper assessment of what those needs are and how best to respond to that. Finally, we need to have a proper process of truth-telling that will also ensure that there is non-repetition in future. Because remember, post-election violence didn't start in 2007.
Indeed,
we had it in 92 and 2097 as well.
Yes, that's right. Okay, thank you all for coming as we discuss this issue. We'll get into your feedback in just a moment. A lot has been said by my panel. I'll leave it to John to just sort of put that very interestingly into perspective for us.